晒你出席啊！仲未得？開埋先啦。等我開咗先啦，好唔好？時間啊過咗啦，人啱啱夠，咁我可以開。
Well, we have just made a quorum. We've passed the appointed hour. The meeting is now called to order. Agenda item number 1, confirmation of minutes of the meeting held on the 21st of May. The Secretary has not received any proposed amendment, so shall we confirm the minutes of that meeting? Thank you very much. Item 2, information paper issued since the last meeting. And there is one. This is an information paper on the financial position of the Applied Research Fund for the period of 1st December 2012 to 28th of February 2013, paper number CB1 1352 1213-01. This is a regular report, and we don't need to follow that up. Item 3, trade relations between the mainland and Hong Kong. Let us invite the government officials into the room first.
嚟緊，官員都到。首先歡迎。
May I welcome Ms. Andrew Wong, Permanent Secretary for Commerce and Economic Development, Mrs. Alice Chung, Deputy Secretary, Mr. Brian Lowe, Deputy Director General of Trade and Industry, and Mr. Johan Wong, Deputy Commissioner for Innovation and Technology. In fact, we have discussed this item before.
多啲關於內地啊同香港嘅商
Members want to discuss more on this topic, the economic and trade relations with the mainland, between mainland and Hong Kong, the Permanent Secretary. In fact, I've introduced a paper. I introduced a paper last meeting. I don't want to waste members' time. At our last meeting, some members were interested in giving more views on economic and trade relations between mainland and Hong Kong. Therefore, we come to meet members to continue the discussion. At the previous meeting, there were 1 or 2 items which we had to follow up, and after we've collated the information, we will provide a paper to the Secretariat. I'm not going to repeat the information in the paper, and we are happy to take questions. Mr. Wong Ting Kwong. Thank you, Chairman. The CE, Mr. Wai Leung, visited Beijing in April, and he said that Hong Kong will participate in the work of drawing up the 12 National 5-year Plan, and the pilot model in Guangdong will be expanded to the Pan-Pearl River Delta region. What is the progress of these matters so far? And what measures does the Bureau have in assisting SMEs and also Hong Kong enterprises to expand their business in the Pan-Pearl River Delta region with regard to the National 13 5-year Plan? This is in the portfolio of the CMAB. As for the timing of the 13 5-year Plan, the administration has already started preparation for consultation. Since it is not my bureau which is responsible for the work of the National 13th Five-Year Plan, I don't have all the details, but we are involved in the economic and trade aspect. As said by Mr. Wong, with regard, we've got the support of the CPG. Those pilot measures will be or have been implemented in Guangdong and will be extended to the 9 provinces. We are following the matter up with the ministries. In fact, the Premier went to Hong Kong, visited Hong Kong, and he said that in the 12th Five-Year Plan, trade between Mainland and Hong Kong should basically be liberalized. And we are talking with the ministries on how to achieve this target. And concerning the areas which have not been opened up, we hope that they would be opened up gradually. We are now talking to the CPG on further opening up the mainland markets to Hong Kong under the CEPA framework.
In fact, we're also keen to see whether there could be more liberalization, whereby we can do it with the pilot and early trial approach through CEPA in Guangdong and also in the 9 provinces in the PRD. We are trying to work hard and we are talking to the central authorities and will report to members and also the public on progress ASAP. Thank you, PS, for that illustration. He said that he would start consulting the industry with regard to the participation in the planning work for the 13th National Five-Year Plan, so that we can let him know or let the administration know the needs of the industry. So when will he start doing so? I said just now that the 13th National Five-Year Plan and work on it would be led by the CMAB. It really depends on the progress of work of that bureau. We can report to you details later on. After liberalization, who will talk to the industries? Is it for your bureau or the CMAB? Are you talking about the early and pilot trial schemes? Chairman, if it's under CEPA, if there are new liberalization measures, our approach all these years has been that we enshrine and entrench them through supplemental agreements. If there is progress, if there are new supplemental agreements or new liberalization measures, we will ask the T&I department to issue news to the industries. We do publish trade notices, and if we do arrive at new liberalization measures, we can also issue news releases to let the public know. This is about new liberalization measures, but we'll certainly work through the different policy bureaus to report to the relevant industries within their purview. Next, Mr. Chung Kwok Pun. Thank you, Chairman. I have 2 questions, please. One, investment promotion. In para 19 of the paper, it is said that Invest Hong Kong in 2013 will continue to mount joint promotional fairs, just like in Zhaoqing and also Fujian going to other places. I'd like to know where Hong Kong stands in such joint efforts. If Guangzhou enterprises are taken to Auckland and they will do their own negotiation, what does Hong Kong do then in that situation, and what benefit is there for Hong Kong enterprises? Secondly, intellectual property. Para 28. You have the Hong Kong Guangdong Expert Group on the Protection of IP Rights. Such products may be registered on the mainland by other people, and such actions like theft are quite rampant. How can this expert group help Hong Kong brands and Hong Kong products if they are registered in Hong Kong already, but they are also registered on the mainland by somebody else without the IP right? What can we do here in Hong Kong to tackle these problems? P.S. First of all, Invest Hong Kong. The objective of Invest Hong Kong is to attract investment to Hong Kong. For many years, we have done this every year, and that is we would mount joint investment promotion activities with major cities in the greater PRD. Mr. Chung cited some examples, and this is done every year. Together with some cities in Guangdong province, we go to target markets to do joint promotion. On the one hand, we like to promote Hong Kong and the PRD as a good destination for investment. People may set up factories in the mainland, but the regional office or headquarters or Asia headquarters might not have been set up in Hong Kong, so we'd like to promote that. And secondly, the central government, of course, is also promoting the policy of going global, and state-owned enterprises and private enterprises have been encouraged to do more promotion. And here the Invest Hong Kong has a role to play. Whether it be SOEs or private enterprises, they can make use of Hong Kong as a springboard. And the Hong Kong service industry can help them achieve the purpose of going global. Therefore, Invest Hong Kong will cooperate with the very relevant provinces and cities. So first of all, we'd like to attract capital to be invested in Hong Kong, and they can use Hong Kong as the anchor. Even if they already have manufacturing plants on the mainland, they can still use Hong Kong as a trade center. And then provinces and cities on the mainland might like to find investment opportunities in the international market, and we will help them mount activities to go global. Hopefully, they can use Hong Kong as a platform or springboard, so they can make decisions about overseas investment. This is Invest Hong Kong. As for copyright issues, for many years, we have worked closely with Guangdong province on promotion of intellectual property rights protection. We have had a lot of exchange with the Guangdong province, and very often, through our cooperation with Guangdong province, where Hong Kong enterprises have operations on the mainland, we have provided information on the system for protecting IP rights of the two places. Mr. Chung was talking about brands and products, and we would let them know how they could apply for such rights. And if indeed there are infringement incidents, we would tell them how to handle such incidents. Through Guangdong Hong Kong cooperation, we would conduct activities so that we can explain to PRD factory owners the differences between the IP rights systems on the mainland and Hong Kong, so as to enhance their awareness and also the awareness of protecting their own IP rights. Chairman, Mr. Chung, a follow-up question. Invest Hong Kong, I understand that many SMEs would like to go global through Hong Kong. But is it a must for them to first set up a company in Hong Kong and engage staff in Hong Kong before they go global? Or is it that when you have taught them how to do it, they will just do it themselves? They will not use Hong Kong in any way. So in the end, how is Hong Kong going to benefit? That's the question. Secondly, IP rights. Can we work through systems like SEPA so that Hong Kong products and brands which have been registered in Hong Kong can be regarded as having been registered on the mainland as well? Of course, I understand there are differences between our systems, but can we make use of policies like SEPA so that Hong Kong brands and products can be protected? P.S. Chairman, on the first question, mainland enterprises can be huge in scale. When these go global, of course, they may not need to use Hong Kong as a platform, but there is also this central policy whereby more mainland enterprises can make use of Hong Kong as a platform. That is what we strive to do. And indeed, it's not just Invest Hong Kong, but also the TDC, which has been engaged to arrange for Hong Kong's service and professional services to go overseas together with mainland enterprises to conduct study tours to see what opportunities there are to make investment, so that when mainland enterprises make investment decisions, they can make use of our professional services. I fully understand that whether it be Invest Hong Kong or TDC, they do not just help mainland enterprises go global without benefiting Hong Kong business, because they're using Hong Kong public money to help mainland enterprises do investment. If in the process there is no benefit done to the Hong Kong economy, it doesn't make sense. Of course, we cannot monopolize such investment opportunities. As I said, enterprises of a certain scale do not have to use Hong Kong as a springboard. But this is what we have been doing, and we have indeed helped enterprises. And that is when they want to make investments overseas, they would work through Invest Hong Kong or the TDC. And in the end, they would set up a company in Hong Kong to manage their overseas investment. This is the policy objective we'd like to achieve through these activities. Mr. Chung also asked about IP rights. We fully understand his question, but even if we are talking about patents or trademarks, according to international IP rights laws, they are quite territorial in nature. In other words, Hong Kong laws can only protect Hong Kong patents and trademarks registered in Hong Kong. If you say if a brand is registered in Hong Kong, can it be automatically extended to the mainland? There is not such an arrangement at present, and there are difficulties in that direction. But through our present activities, we hope to allow Hong Kong businessmen to understand better what they can do to seek similar protection on the mainland, and also if they run into difficulties, what actions can be taken on the mainland. We hope we can help Hong Kong businessmen in this regard. Actually, Mr. Chung's point is very valid. P.S. On IP rights, the two systems may be different. But can you help businessmen understand what procedures should be undertaken on the mainland? This is done every year, Chairman. We cooperate with the Guangdong province to conduct such activities in the PRD, targeting Hong Kong businessmen who invest on the mainland. Just now, Mr. Chung also mentioned that you would conduct joint business promotion activities, but maybe the two places have different conditions. In Hong Kong, we have a simple and low tax system, but the mainland has other advantages. Would there be competition between the two places, fighting for business between themselves? Did that happen? Chairman, just like what we said in the paper, every year in selecting markets for doing joint promotion, Invest Hong Kong and the counterpart on the mainland would discuss beforehand. They may be interested in certain markets, but those may not be markets we want to tackle as priority. There is this process every year, so we can discuss. We may take it up with Zhuhai, Zhaoqing or Guangzhou to see where we want to mount promotion. We like to achieve a win-win situation. We would like to find some products and services that we both want to promote. So first there is this process, and secondly, such promotional activities seek to promote the business environment of the various cities and provinces, and then Hong Kong. It's a general kind of promotion. In the end, it will be up to Invest Hong Kong to also conduct their own large-scale seminars to get in touch with interested companies. And then we'll have to send staff to these companies to talk to their management to see whether they want to invest in Hong Kong. So in general activities, usually there is no competition between the mainland and Hong Kong for investment.
Mr. Mao Fenghuo. Thank you, Chairman. I have two questions. The first one is on films. I'm also the chairman of Film Development Council. I took office a few months ago. With regard to promoting films, there are problems. We did some work last time, but there was not much achievement. Now, for Hong Kong-produced films, the trade wants to distribute them in Guangdong and Guangxi, where Cantonese is spoken. But they are not able to do that, mainly because of the bureaucracies of the mainland. Now, can there be simultaneous distribution? Now, say a film which is distributed in Hong Kong for half a year, then is distributed in the mainland, that will be too late. The disc and also the tapes will have been sold widely already. And I really don't know what can be done by the administration to help simultaneous distribution. And the other is on publication. The creative industries, say, participating in the South China Book Fair and also the Beijing International Book Fair. Now, this is not promotion. I'm not talking about promotion. The publishers in Hong Kong, can they be given the book number? Now, when they go to these book fairs, the Hong Kong publishers will have to ask a mainland agent to do the publication for them in the mainland. Is it possible to work with the mainland as SIPA? Every year, certain book numbers can be given to the Hong Kong publishers. And of course, such books have to go through the censorship process in the mainland. But is it possible to have publication in the mainland? They cannot control the distribution, and they don't have much profits if everything is done by the mainland agents. I'll speak on that, and then the Deputy Director will supplement. Concerning the two questions by Mr. Ma, this is not the first time we've heard about them. In fact, the trade did talk to us, and they hoped that through SIPA, something could be done so that the mainland market could be open to them. The system in the mainland is different. As said by the member, in terms of execution, there are rules and laws in the mainland, and will such rules and laws be adjusted because of SIPA? On many fronts, we've encountered that. if it is about a change in the regime, it will take a long time. It's not just opening up the market. As for the two issues raised by Mr. Ma, when we consulted the trade on what further things we can do under CEPA, I've heard about these, and I have already reflected these demands to the ministries concerned. Perhaps Mr. Wong can supplement. Thank you, Chairman. If I may just make a short supplement. On the 18th of June, at the joint working group under CEPA, with regard to film industry, many film producers want to have simultaneous distribution in Hong Kong and in the mainland. That's about implementation of CEPA. The measures are there under CEPA, but or rather the provisions are there under CEPA, but there is a problem of implementation. We will reflected the views to the authorities of the CPG and also the provincial authorities. In Guangdong, there is a new measure, and that is the approval of film exchanges organized in Guangdong, and that has already covered Cantonese films produced in Hong Kong. As for the introduction of such films, the administration on broadcasting and telecommunications adheres to the established procedures. We have reflected the view, but in terms of national policy, no undertaking has been given in terms of liberalizing the market. As for approving film exchange activities in Guangdong, I think the procedures will be shortened, and that will facilitate the distribution of Hong Kong-produced films distributed in Guangdong. As for the achievement of this of the joint working group, I have already informed the trade about that, and we are collecting further information so that we can follow the matter up. What about the books? It is also about the regime. We know that there is such a demand, and we'll talk to the CPG, but we don't have any achievement yet. On the first question concerning the film industry, now the Film Development Council has a plan. As for those who want to distribute their films in the mainland, we can provide funding, but the industry doesn't come along to apply because it takes too long, and when they put up their films for showing, it's already too late. If that is simultaneous distribution, then the situation will be very different. Now, concerning this joint working group under CEPA, 6 ministries and 7 administrations or departments, bureaus in Guangdong. I don't know what they are doing. Now, for film festivals, they have already decentralized a bit. So what is the problem with simultaneous distribution, and how can that be overcome? As for publication, my understanding is there aren't too many policies. I think it's a matter of interest. If the ministries are willing to relax, that will not have any adverse impact. It's just to give some more ISBNs to the Hong Kong publishers. It doesn't affect censorship. It doesn't affect the law. Can the administration work hard on this? I think the point raised by the chairman and Mr. Chong is about IP, and I'm concerned about it. In fact, we can do that. We can have mutual recognition of trademarks and brands. How can we cause this to happen? It is one country, right? This can be simplified. That can be facilitated. It will help us a lot. These are real problems. Yes, indeed, we've heard it. We will actively pursue the matter with the CPG, but the ministries of the central and also commissions of the central government have to be willing to change their certain practices. We understand that it takes time to talk to the central government. I think it's all about interest. I understand that. I hope the administration will keep pursuing them for us. Mr. Lam Tai Fai. Thank you, Chairman. When it comes to the economic and trade relation between Hong Kong and the mainland, the business people, the people of Hong Kong focus on attention how Hong Kong people can expand their market in the mainland, and also have production in the mainland and then sell the product in the mainland or sell the product overseas. Greater cooperation between Hong Kong, Guangdong, Hong Kong, Shenzhen, Hong Kong, Shanghai, enhancement of the trade offices, strengthening CEP, CEPA, facilitating the custom clearance, facilitating the handling of labor disputes, and also IP, so on and so forth. Well, it's a mutual interactive relationship. Now, the mainland is a big market, but have we neglected Hong Kong? Now, we go in, they also go out. If there is no chance for them, they go to Southeast Asia, they go to UK, they go to Europe, they go to Singapore, they go to Japan. They will not benefit Hong Kong. Why can't we attract investors, mainland investors, to invest in Hong Kong? Mainland companies just come to be listed in Hong Kong. They come here to raise funds. They come here to get money from us instead of investing in Hong Kong. They come here to buy property. No, the harsh measures. They want to invest in the long term. No, they can't because of stamp duty. Buy baby formula. No, restriction. That is restriction. And the retail business is going down. The IVS, $0 tour, and also retail floor space. In fact, with the decline in IVS visitors, they do not. They are not too eager to make purchases in Hong Kong. Some said that they are not treasured as they used to be, and they lack the enthusiasm to make purchases in Hong Kong. Now, how can you encourage mainlanders to invest in Hong Kong, do business in Hong Kong, so as to enhance the prosperity of Hong Kong? Or you just hope that they can come to be listed only? As for tourism industry, we have the cruise terminal already, and we're going to expand the Disneyland, the Ocean Park. We are attracting tourists. We also hope that when they come to Hong Kong, they can find Hong Kong a place to do business. What policy do you have to attract mainlanders to invest in businesses in Hong Kong? The Permanent Secretary. As for mainland companies coming to Hong Kong to be listed, making Hong Kong as a platform for fundraising, this is in fact Hong Kong's advantage. The Invest Hong Kong goes to the various cities in the mainland to bring mainland companies to go global and to bring mainland companies to Hong Kong. And we have seen encouraging outcomes. Every year, mainland companies investing in Hong Kong has been increasing in numbers. they don't just come to be listed. They come here to do business. And even if they have companies in Hong Kong, they will expand the scale of operation. That's exactly the work of the Invest Hong Kong, and it has been doing that over the years. Now, can you tell us what are the areas in which the Hong Kong SARG wants mainland investors to invest? Certainly not industry, because there is no prospect for industry. What areas would you like them to invest? Probably not the Cha Chan Teng or local cafes. Every year, the Invest Hong Kong follows the advice of the government and consider what businesses are having advantages. Say, for example, Hong Kong is the center for financial services, for Hong Kong is a transportation hub. These are the strengths of Hong Kong. And we work through the Invest Hong Kong and seek relevant companies to in the mainland to come to do business in Hong Kong. We also try to develop innovation and technology. We want to promote creative industries. These are the advantages we have.
Through Invest Hong Kong, we like to attract companies from all over the world to start the business and also to expand the business if they're already here. P.S. If there is a chance, can you show me examples except China Travel Services? Have there been private enterprises from the mainland coming to Hong Kong, making the business work? Every year in January, Invest Hong Kong submits a report, and the director of Invest Hong Kong will personally come to this panel to report his work of the last year to you. Maybe this time around I can remind him that he should give such information to particularly Mr. Lam Tai Fai. I'd like to also add Chinese traditional medicine. Can we attract them to come to Hong Kong to set up factories? P.S. Please also take note of this. P.S. It seems that when Hong Kong people set up business or factories on the mainland, they are bound to meet up with a lot of difficulties. Is it that when they meet up with difficulties, they can approach your offices so that they can get help? Or is it that you would actively contact Hong Kong factories to see if they have problems? There are many, many difficulties. Chairman, certainly Hong Kong is the biggest investor in PRD. We now have 4 offices on the mainland. Hong Kong people or Hong Kong businessmen, if they should encounter business problems, they can contact our offices on the mainland. Our staff can reflect the problem to that local government. And if it is Guangdong Province or PLD, we have a standing arrangement whereby every year we have some time devoted to upgrading and transformation, particularly relating to Hong Kong businessmen. We have an annual meeting together with the Guangdong Province to reflect the problems encountered by Hong Kong businessmen in the PRD. We make use of this platform to share those problems with the Guangdong Province. Round about this time, every year, we will sit down with the relevant trade associations or chambers of commerce to listen to them, what problems their members have told them about. And also through our office in Guangzhou, we contact directly Hong Kong businessmen in the PRD to try to understand the latest problems so that the Hong Kong SARG can reflect those problems to the Guangdong Province. This is an annual exercise. we consult Hong Kong businessmen, then we have meetings with the Guangdong province, and the results of our discussion would be dispersed through the chambers of commerce or trade associations. If there are expected changes in policies and measures in the coming year, we'd like to alert Hong Kong businessmen to them, so they are given advance notice. That has always been done. Thank you. P.S. Emily Lau. Thank you, Chairman. After lunch, we hope to get home visit permits so we can take part in study tours on the mainland to see how Hong Kong businessmen are assisted. I don't know whether Mr. Zhang Shaoming can help us with those. Chairman, you talked about business problems, but as you know, the LegCo has received a lot of requests for help, whereby Hong Kong businessmen have been arrested and the whole family is broken up. It is not your work, it seems. We have Ms. Cheung King Yiu, who is the other PS. She has been here at the panel. I have handed over cases to her, but then those cases have not been resolved. Now, I don't care which bureau it is, and I don't know whether the PS knows how many such cases there are. There are many. These are Hong Kong businessmen who have trusted the mainland. They go back to conduct business and they are troubled by corrupt officials, but then you are passing the buck around you. Sometimes you go to they go to see NPC deputies or CPPCC members or the LegCo. So please, PS, do not push everything to Ms. Cheung King Yiu. Do you know that Hong Kong businessmen have been thrown into jail or have become bankrupt just because they conducted business on the mainland? What can we do? PS. Chairman, wherever Hong Kong businessmen go, they may bump into similar problems. But my understanding is that if Hong Kong businessmen do encounter such problems and they seek help from our mainland offices, these officers will try their best to help. But members will understand that if they are purely business disputes, it will be difficult for the government to intervene. It depends on the various cases, and it's very difficult to say in general what the government can do and not do. But if Hong Kong businessmen should come to us for help, we will look into the case and to see what help can be given. Chairman, some courts have upheld the case for Hong Kong businessmen, but there was no follow-up done. Sometimes they have been arrested themselves. You know, before 1997, the then Hong Kong government could pay visits to them, but now not even the SALG could visit Hong Kong businessmen in jail. PS, can you let us know the arrangement? Not even their family members can visit them in jail. They cannot seek help anywhere. They are just trying to do business. They just like to make some money to help people and themselves. If the SALG can give some help, I'm sure it will make a difference. But they have been unwilling. They have been citing excuses, and Hong Kong businessmen are left on their own. So do you know how many such cases there are? Chairman, indeed this is not within the portfolio of my bureau, but I can relate the question to the CMAB and let them know the question and see what information they have. But I find this strange. I'm talking about Hong Kong businessmen. How can you pass the buck? These are Hong Kong businessmen, PS. They are Hong Kong businessmen. They bumped into trouble on the mainland. And then you say it is not for your bureau to help them. This is not very nice. But you will relate the issue, right? Mr. Martin Liao? In the past 30 years, the mainland economy has taken off, and cross-boundary traffic between Hong Kong and the mainland has been picking up. There are also huge increases in the numbers of Hong Kong businessmen working on the mainland. All these years, the sector and also the government have been trying to improve the trade and business environment, but then, of course, there is still a lot of room for improvement. On the other hand, it is unfortunate that according to a news report last week, and also the FTU Dongguan and another information center had it that labor disputes have risen by 50%, mostly involving pay in arrears and also the invalidation of the work permit. Now, I don't know whether we should ask UPS or the CMAB. Your offices on the mainland, what can be done by them to help Hong Kong people in such situations? And if necessary, will the SARG take up such matters with mainland governments? P.S. I think it's a similar question as the last one. Chairman, if you're talking about individual cases, it really depends on the merits of each case before I can say whether our offices are in a position to help. If it is about information, certainly that can be supplied by our ETOs. Say, for example, they can refer businessmen to certain channels or organizations to try to find answers. But if it is really about a dispute, it depends on the individual case. It's very difficult for me to say in general who we can help and who we cannot. I'm sure when our officers receive such requests, I'm sure they will do their very best to see what they can do. As to whether the SARG should step in, well, the officers on the mainland are already representatives of the government here. If they think they are in a position to intervene into anything, and if they can communicate with the provincial or city governments, then that would have been done on behalf of the Hong Kong SARG. Martin Liao, a follow-up. I was not talking about individual cases. I was talking about a rising trend of 50%. I hope the SARG should show some concern and try to seek an understanding into the issue. Is there a structural reason behind this? And as you know, our ETOs on the mainland can have exchanges with mainland governments, but they are not on a par in terms of rank with mainland officials. So if it is a structural problem as such, perhaps the SARG has the responsibility to face up to the issue and take up these matters with the mainland governments. I don't think you can solely rely on your officers on the mainland. Chairman, if members are talking about policy changes leading to conflicts, I think I explained that already. If there is a policy change, so Hong Kong businessmen's operation on the mainland is affected, then we would like to talk to the central government or through the Guangdong government, because most Hong Kong businessmen are in Guangdong. Every year, we would consult local trade associations or chambers of commerce, and then our officers would also communicate with Hong Kong business on the mainland to see what concerns they have with regard to new policies or even policy proposals. The SARG will take this up with the heads of city governments or even at the central government level. If there are new regulations or policies which are going to affect the operation of Hong Kong businessmen, we would raise them. And there was this example recently, and we reflected the concern to the to the Ministry of Commerce, and in the end some adjustments were made. This is what we do. And we do undertake such exchange with the mainland to reflect views, but we don't normally intervene into cases. I think if you say we need to negotiate or intervene into certain cases with the mainland government, that might be too serious a portrayal of the situation. But we do reflect views to the relevant units on the mainland. Chairman, if you don't mind, I'm not talking about Hong Kong businessmen. Just the contrary. I'm talking about Hong Kong people working on the mainland, that they are not paid their salaries, and also their permits would expire. I'm not talking about Hong Kong businessmen, but Hong Kong employees on the mainland. Chairman, if individual Hong Kongers have difficulties on the mainland, they can approach the SARG offices. Wherever possible, we will give help. But I cannot comment on a particular case and be asked to ask the Hong Kong SLG to take up with the ministries and commissions concerned. Next, Mr. Sin Chung Kai. Chairman, Ms. Emily Lau put her finger on the issue, and Mr. Martin Liao also mentioned the problem of employees. Actually, members of LegCo from different political affiliations have touched upon these issues. I think all these years the SALG has not been proactive in tackling these cases. Next time, you should systematically collate such information for us, and that is every year how many cases have been received by each office and what categories these cases belong to. Maybe you do not have jurisdiction to follow up on all these cases, but say you have 2,000, 3,000 or 500 cases every year, and you can categorize them and let us know the difficulties involved.
You can compile a report, and you also have working groups, say mainland relation, the CE, the CSOA have connections, and you also have other officials also have connections. We have not seen any report. Now you say you can't help with individual cases, but can you take note of the problems, categorize the problems? Even if you can't follow the case up, you can still do some basic work, some statistics and some research. I don't think you have done that at all. This is very basic. Even if you don't handle an individual case, you should collect data, information on nature of the case, what are the problems. Now you can say, I can't follow up your case, but I can record that. Even if you report to the police, if they can't follow the matter up, they can still make a report. They can still make a record. You can't even give us the numbers. Yes, I'll reflect the suggestion to the CMAB. I'm not looking after the ETOs in the mainland. Ms. N. Cheng. Thank you, Chairman. I sympathize with the PS. The DAB received many such cases, which ask for help. There are certain cases that are easy to handle. Usually they are in Guangdong. When we raise that with the Guangdong provincial government, they are willing to help. Say, for example, the failed housing development projects. One of the examples. Now, some may be individual cases, say a dispute between a company, a Hong Kong company with a mainland business partner. That's something we can't do much. It is very complicated. And as a third party, we cannot interfere with that, and we are not legal professionals. We just ask them to get mainland lawyers or Hong Kong lawyers who are familiar with mainland legal matters to assist. My question is not related to that. I've heard that the Invest Hong Kong has done a lot to to attract mainland investors to come to Hong Kong. Yes, I know, Mr. PS, you have done some work. But apart from doing something in relation of financial services or tourism industry, can you also invite some or attract some mainland companies to invest in Hong Kong that can assist our GDP growth? Say, for example, invest in Chinese medicine, high-class mainland food. Now, these products have difficulties of direct export, making direct export to overseas countries. Mainland people sometimes don't have confidence in their own baby formula and in their own food products. Now, can Hong Kong help these food producers? Their foods can be exported in Hong Kong, or certain their food and medicine can be, say, certified in Hong Kong and then exported. I hope the PS will consider that together with the Director Bureau. I heard that Hong Kong would participate in the planning of the 13th five-year plan. In fact, CY has also said that Hong Kong will participate in preparatory work. Now, in the preparatory work of the 13th five-year plan, apart from including the elements of financial services and tourism, can food and medicine be another sector? In fact, Hong Kong has a high standard in terms of certification. In the mainland, there are many big manufacturers, big factories. They have big pharmaceutical companies. There are many big pharmaceutical companies, and they are doing quite well. If they can be attracted to Hong Kong and then expand their business through Hong Kong, that will contribute a lot to our GDP growth. The PS. Mr. Chairman, with regard to attracting overseas investments into Hong Kong, including investment from the mainland, we have strategies. Some sectors or industries may be given priority. As said by Ms. Chang, our certification is industry is a strength. Is our strength, and that's an industry which we focus attention on. And our promotion in this regard is to attract companies to invest in certification and testing in Hong Kong. We welcome any investment in whatever industry. I think we spend quite some time on this item, and we nearly used up the time allocated. We are concerned about the operation of the ETOs in the mainland, and I believe they will come back, the officials will come back to Hong Kong in November. Can they report, can you ask them to report to us? In fact, every year the head of ETOs come back to Hong Kong to report to the LegCo. I think it is in November or October, 25th of October. Yes, there will be a chance for them to report to members on their work. Thank you. Next, item 4, public consultation on treatment of parody under the copyright regime. This item is common concern. It has attracted public attention widely, and therefore the Secretary for Commerce and Economic Development is leading the team. May I welcome Mr. Greg So, the Secretary for Commerce and Economic Development, Ms. Patricia So, Acting Deputy Secretary, Mr. Peter Chang, Director of Intellectual Property, and Ms. Fanny Pang, Assistant Director of Intellectual Property. Welcome, Mr. So. Now, in phase of rapid development of knowledge-based economy, we need copyright regime to be kept under review to ensure that it's in our best interest. With regard to the rise in parody in the Internet, many people make use of existing copyright products or assimilate copyright products in order to do parody. A parody covers a wide spectrum and people have different views. In overseas countries, they have the latest development in regulating parody, in dealing with parody, and we are looking at that very closely. We issue a paper for consultation 11th July, and we try to consult the public on how to deal with parody under the current circumstances and suitably treat parody, so as to balance freedom of expression and protection of copyrights. And we've proposed three options for discussion, and they are for members' discussion. As for parody, including the concept of parody, the comments in respect of opinion towards parody, current legal situation, and overseas practice are in the paper. I will speak on the three options. First, option 1 is to clarify the criminal sanction. Under this option, we will clarify the existing distribution offense and the proposed communication offense in the Copyright Amendment Ordinance in Copyright Amendment Bill 2011. The court, in deciding whether an infringing act is an offense, has to consider whether the act has caused more than trivial economic prejudice to the copyright owner. Relevant factors will be set out for the court's guidance so as to highlight the legislative intent. Now, if parody that it is distributed in the Internet and will not cause any prejudice, it will not lead to any criminal consequences. That's part of the CSA. We moved last year. In fact, we got the support of the Bills Committee. Option 2 is to provide criminal exemption to parody, as long as certain exemption criteria are fulfilled. Distribution or communication offenses will be exempted. And in the consultation paper, we propose the following. Say, it doesn't cause more than trivial economic prejudice to the copyright owners, then the parody will be exempted. And what is meant by more than trivial economic prejudice depends very much on whether it will replace the market of the copyright products. We need to honor international obligation, and we need to follow the discharge obligation of TRIPS. We need to have criminal procedures and penalty for commercial copyright piracy. We need to set suitable criminal exemption conditions to provide criminal exemption. And option 3 is to introduce fair dealing exception. Under the scheme, we will introduce fair dealing exception. And if the parody is a fair dealing, then distribution and keeping of parody will not lead to civil or criminal liabilities. And we can also make reference to the present practice of the copyright ordinance and adopt a listing approach, though the list is not exhaustive. That includes the purpose and nature of the parody, the purpose and nature of the original product, and also the actual part and proportion of the original product, and also the parody's impact on the potential value of the copyright product. We have already provided the details in the consultation paper for members' reference. Our position is that we have an open mind towards the three options. We welcome members of the public to give their views before the 15th of October. We'll organize public forums to encourage stakeholders to exchange views on the pros and cons of various options. We've noticed that some want to extend the consultation period to more than 3 years. We have just started the consultation. We will first listen to your views, and later we will consider this topic. We hope that through this consultation, we can gauge the mainstream opinion. We will consider the views carefully, and we will decide how to deal with parity. Thank you, Chairman. Mr. So, before members ask questions, I want to tell the Secretary something on the consultation period. In fact, Ms. Claudia Mo has sent a letter to me. The 3-month consultation period will end the 15th of October, but the LegCo is in recess. The first meeting is the 9th of October, and the first meeting for the panel is 25th of October. And on the 25th, we have already got agenda items for discussion. Is it possible, Mr. So, to defer the deadline to at least the 15th of November so that we can have a hearing? During the summer recess, there is no time to conduct a hearing. And this also gives members of public the impression that you lay an ambush. When we are taking a recess, you conduct a consultation, and that will tarnish your image. Can you extend the consultation period? Mr. Chairman, I'm happy to accommodate to the LegCo's timetable. I have no intention to lay an ambush during the summer recess. We will accommodate to the timetable of the LegCo. If need be, if you want a hearing, then we can extend the consultation period. But as for how long should we extend the period, I do not want to fix a date. I will accommodate to the work of the LegCo, including the deputation, hearing the deputations.
If the response will be very warm, and we'll see, but the consultation period has just begun. Let us see how things go, but our major premise is to work together with LegCo. Well, the quickest for us to have a hearing would be end October, early November, and that would be past the deadline set by you. You can rest assured we will certainly consider the extension of the consultation period so that we can complement your work, including the public hearing you have mentioned. Thank you so much. Now members can ask questions. Claudia Mo. I am really so grateful to you, Chairman. I don't always compliment you, but you have really successfully secured the extension of the consultation period by a month. Thank you for taking seriously my letter for requesting an extension of the consultation period. I believe the devil is in the detail. The consultation this time around is still very complicated, and I don't think it can be concluded within 3 months. Can you combine, for example, options 2 and 3? First of all, you say, well, I really can't manage the Chinese term for parody. As long as it is non-commercial, can you exempt them? This is not the only exemption, but if it is non-commercial, let us just exempt them. And I'm not really talking about more than trivial economic prejudice, because it is very difficult to define. And secondly, if it has a certain social or political message. But you say this is very difficult to define legally. Can we, for example, use the public interest for the media? If there is a kind of public interest as for the media, then it can warrant exemption. If option 2 and option 3 will remain separate, the netizens will not be reassured, because after all, there has been no prosecution. I understand there was another case, but it was not about parody. So basically, netizens would just like to preserve their existing freedom. They just like to see what they can do now continue without having them taking up extra legal liability. But if this becomes law, then they will be frightened off. But of course, you can say people can be reassured because they can talk to the judge in court. You may not be a journalist, but you will have this worry in your heart. Of course, journalists would have to always cite public interest. And of course, netizens, if they do not engage in parody, then they will not be in trouble. But then, this is exactly what parody is about. It's about freedom. It's about rights. If these are existing rights, these are existing freedoms, and if they are deprived of the public as a result of a new law, then I think really want to look very close at it. And also the details. If copyright owners should complain about infringing of their copyrights, then you can then open a file for it. The thing is, if the copyright owners themselves don't think it is a problem, and yet there is another person making a complaint, for example, the checkers, it may be black and white or other color combinations, then another person can complain to the police that there is infringement. However, I'm really very worried by how your consultation paper is worded, that the devil is in the details. Even if you have a 6-month consultation period, we cannot iron out all the details. Well, many members would like to ask questions. I will now limit members' time to 4 minutes. You did not put a limit to my speaking time. I was so happy. But now I will kick off the time limit. I don't think I can answer all those points within 20 seconds. Can you give me a little more time? Yes. I thank members for working closely with us so we can strike a good balance between the rights of copyright owners and parody use, and so therefore the freedom of expression. I think the issue is indeed complicated, and I understand why members would like to take a close look. Ms. Claudia Mo asked whether option 2 and option 3 can be combined. Actually, we have an open mind. If Ms. Mo is of the view that there could be an option 4, so that the merits of option 2 and option 3 can be extracted and combined into one, then we would be very happy to consider that. But in para 26 of the consultation paper, we have said that these are our guiding principles. First of all, there should be a fair balance in the law, as I said. And secondly, we do have international responsibilities. Option 2 targets criminal liability and exemptions. And internationally speaking, in our agreements, there are criteria for us to abide by. For example, Article 61 of the Intellectual Property Rights Protection Agreement, and this is different from civil cases. And also Article 13 of the same agreement, it talks about the exemption criteria, and there are 3 steps for doing the test. So the civil and criminal liabilities are different, and perhaps we have to understand better what option 2 and option 3 are about and see whether we can discharge our international responsibilities. And you're right, Ms. Mo, the details are important. We have issued this consultation paper so you can look at the details, say, for example, the conditions for exemption. We'd like you to let us know. In the annex, we have put our words for or diction for your consideration. But you should not be limited by the list. You can certainly explore into the issue. However, we have to remember our guiding principles, and that is we have to abide by international responsibilities, and also we have to make things that are akin to the Hong Kong situation. Charles Mock. Mr. Secretary, you have again issued the consultation on copyrights and parody. Many members of the public and netizens have already spoken out they actually question you. They call this the Cyber Article 23. I'm afraid that this is because you have lost the trust of the public, and that is why you are fighting an uphill battle. So good luck to you. The original amendment, of course, is not mentioned in the paper here. Say, for example, safe harbor, communication rights, and also deleting and infringing product, etc. All these are not the subject of consultation. However, they are also important about copyright protection. Last year, the administration would not budge on parody, and that is why we have this consultation today. There are many specific questions which can hardly be answered today because they are complicated. Together with my staff, I have visited the golden chat room, and I have already identified quite a few. Should we have an amendment or should we not? Because if we look at the paper, it says that it is quite safe now for netizens. I'm talking about the chances of being prosecuted, and if the netizens say they are already quite safe, then why do you want to change things? It seems you are testing people in a Hong Kong DSE exam. You are making use of different terms, but they are not defined legally, including parody, satire, caricature, and pastiche. And also enforcement, would that be selective? Ms. Mo talked about political parody. However, people in the cultural and arts field have other worries. You may be talking about economic or commercial interests that can be harmed. Therefore, I would say that you should have a longer consultation period, and I am happy to say that you are open as to the extension of the period. I hope you will tell us for how long it will be extended soon. And also with regard to your public forums, how many are you going to organize? And like other pieces of legislation, you would have such seminars or forums throughout the territory. Will you do that? Like last time you consulted on the obscene and indecent articles ordinance, and also some deputations said that in the past you only gave them 24 hours notice, and they said that you were not sincere, so they did not attend. Would you now invite them to be consulted again, so you show your sincerity talking to these people? I'd also like to add that with regard to Ms. Mo's letter, she said there should be a public hearing, and I'd like to reiterate a point not mentioned by the chairman, and that is we would like to have a joint meeting with the ITB panel, because this indeed has to do with both panels. I hope you will take this up with the other chairman. Again, I need more time because there are many questions. You need more time for every member. Ms. Charles Mock mentioned safe harbor, etc. Indeed, in the last session, this is what was included in the amendment bill. But this time around, we'd like just to concentrate on parody and how it should be tackled. That is why we are not talking about safe harbor, for example. And also, is it that the present ordinance has already struck an appropriate balance? This is because we have heard the views of netizens as well as copyright owners. So this time around, we would like to have an open and honest consultation to see whether we can arrive at a mainstream view. Like option 1, at this stage, would like to clarify again on the basis of court cases. So we know that if there is the causing of more than trivial economic prejudice to the copyright owners, then there could be a legal framework to deal with it. And of course, option 2 also makes things clear that there would be criminal exemption, and also in terms of civil exception, we would like to work along international standards, and that is why we have option 3. If we can set very clear standards, I'm sure given the spirit of the rule of law in Hong Kong, there will not be selective law enforcement. And I believe you will find law enforcement appropriate. As for commercial interest, we hope that in this consultation we will make it clear that what are the commercial considerations for exception. I'd like to hear more from you. Mr. Mark also said that some people said a 24-hour notice is not enough. Now I hope that we would have the chance to have an exchange with them before consultation actually starts. If they think the 24-hour appointment is not enough, I'm happy to tell you that we have already made an appointment with them for mid-August so that we can have exchange. Thank you, Ms. Anne Chang. Chairman, first question for you is whether you can tell us in detail why secondary creativity will become parody in your paper.
We have all been using the term of secondary creation. Suddenly you change into parody. Is there a change in definition? And is it something new? Thank you, Ms. Chang, for the question. We've noticed that local media and netizens locally use the term secondary creation to deal with the working on copyright products. But secondary creation is not a commonly used concept in copyright jurisprudence, and the area covered by this term is difficult to define. Say, if there is any deliberate commercial copyright infringement, this may be a kind of secondary creation. But what we want to address is parody, or terms used in common law jurisdiction. Say, for example, parody, caricature, satire. These are the terms used in common law jurisdictions. And we use parody to stand for all these terms. If you look at our consultation document, we want to ask you whether you want a definition for parody. In overseas jurisdictions, they do give exemption to parody, but they do not give a definition, because there are difficulties of making a definition. As for the if we adopt a certain description, then we may not be able to use overseas case laws as precedents. We need to we therefore want to ask you, if you need a definition, how should it be defined, and how can that be dovetailed with international practice? Yes, Chairman, where does the word parody come from? I thought it was a mainland term. In Cantonese it's hei fong. I asked mainland people, they said it didn't. They did. They use the term secondary creation, or 二次創作, and parody is just one kind of secondary creation. When you say parody is a kind of sort of playing a joke or making a joke of a certain product or a certain person or object. Now, if the person is serious, he's not just making a joke, then can it be regarded as a parody? I don't understand why you narrow the scope of secondary creation to just parody. Parody gives people the meaning of playing, joking, just makes the head or heads and bodies of different celebrities and then sell these toys, then is doing business. Well, I'm referring to parody, satire, caricature, and pastiches. These are terms used in overseas jurisdictions. It's also about infringement of copyrights, and we need to adopt the terms of overseas jurisdictions. And we try to we hope that you can give comments on the elements that we should take into account in giving exemption. Mr. Dennis Kwok. Time is limited. I try to be precise. Now, the Copyright and Design Patent Act 1988 said that
affects any rule of law preventing or restricting the enforcement of copyright on the grounds of public interest or otherwise.
Now, this provision is very important. In the European Human Rights Court and also in UK courts in recent years, there were certain developments. Say if a reporter or if the newspaper in dealing with public interest and report on public interest and report on a lot of on important matters, and if there is any infringement of copyrights, then the court can balance public interest vis-à-vis the rights of the copyright owner. The copyright owner, copyright is protected, but this is not absolute. When certain reporting involves important public interest, the court will have to balance that. The British Act has a special provision when it comes to serious public interests or important public interests. Copyright is not absolute. My colleague, Ms. Claudia Moe, has already mentioned that secondary creation are usually related to important political or social issues. Now, will the Bureau consider adding a similar provision like the UK to protect the comments and also secondary creation based on public interests? Thank you, Chairman, and thank you, Mr. Kwok, for his view. Under Section 192, subsection 3, there is already such a provision. This part does not prevent the enforcement of copyright under public interests. This has already included the British provision here. In fact, Section 39, to answer Ms. Mo's question, Section 39 also deals with fair dealing in respect of news reporting. Now, considering the two cases I mentioned, one is rock and roll and the other is SB Donald. They are UK cases. They have clarified the definition, or they have clarified what is meant by public interest. They have further expanded the scope of public interest, and that involves freedom of the press and also matters of important public interest. This is an opportunity for Hong Kong to clarify the rights. In fact, Mr. Chairman, apart from public interest mentioned by Mr. Kwok, we're talking about expression being exempted under the scope of parody. As for UK, they did a consultation recently, and they intend to legislate on parody. We are watching the development in the UK closely. In fact, we've also provided the information about that. Now, concerning the term mentioned by Mr. Kwok is a general one. Now, if it is a copyright matter, and it should not, if it is not to be enforced, it must be based on public interest, and the court will have to weigh this. In fact, our copyright law is similar to that of the UK. In UK, starting from 2006, they had a consultation on parody, and after 3 years, they came to the conclusion that it may be necessary to give exemption to parody within copyright laws. They are drafting the provisions. Now if parody is a parody will be exempted under fair dealing, and it has still to be enacted. But we are watching the situation closely. Next, Mr. Chung Kok Pan. Chairman, we all know that there is no national boundaries in the cyber world. Say, if the production is in Hong Kong, law can be enforced. But if it is done in Shenzhen and then shown in Hong Kong, then how can you enforce the law? The Secretary, we update this ordinance. This is about parody. As for enforcement, that's another matter. We want to focus on parody. As for law enforcement, I think the Director can speak on that. Thank you, Chairman. And thank you, Mr. Chung, for the question. Say the enforcement of local law is done by the local law enforcement agency, and it has to be based on where the act takes place. If the act takes place in Hong Kong, then litigation, civil or criminal litigation, will be conducted in Hong Kong. In the cyber world, things are conducted in the Internet, but the act has to be related to Hong Kong if the Hong Kong law is to be enforced. The copyright owner must make a complaint in Hong Kong, and the C&E department has to collect adequate evidence to show that the infringement is not authorized before there is any consideration for criminal prosecution. Mr. Chung, any follow-up? No, then Mr. Ronnie Tong. Thank you, Chairman. I thank the Policy Secretary for amending the proposal to give exemption to parody. It seems that the instant response is that the netizens are not willing to accept that. Now, concerning the proposals, option 1, the beyond, or rather more than trivial economic prejudice. Option 2, criminal exemption, and then option 3, fair dealing exception. Within a short period of time, according to the opinions I have noted, people are a bit worried that there is no definition for parody. Whether it is secondary creation or parody, I think the expression is different from that overseas countries or overseas jurisdictions. We don't have those T-shirts which is a parody on a political party. And I think we need to consider matters of principle. Mr. Dennis Kwok has mentioned public interest, but it's too vague. Now, can you say adopt principles like fair comment in defamatory law? Say if it is a commentary on public affairs, then this should be exempted. Whether it's a parody, whether it's serious comment, or whether it's a parody with malice intent, that should also be exempted. If you use that, if it is just parody, it seems that it's not serious. It's just a joke. But some people suffer, who are at the other end of the criticism may think that that's a malicious criticism. It's something that he cannot accept. Say if you say any criticisms, discussions, which have no intention to duplicate or to infringe a copyright to make profit, it will be dealt with similarly, like fair comment in defamatory law. Will that be acceptable to you? I thank Mr. Tong for his view. When our bill was being discussed and concerning the comment concerning the principle of more than trivial economic prejudice, Mr. Tong has given a lot of valuable comments. Now we want to find a suitable balance. As I said, we have no preconceived position. As long as clear, as long as it's balanced, as long as it can fulfill our international obligation, I'm happy to consider any option.
Even if Mr. Ronnie Tong would come up with other options, I will be happy to consider them. Our consultation paper also asks whether there should be a definition. If yes, how it should be set. In other words, you are quite willing to define parody. Well, actually, we have already said that parody this time around would include satire and caricature. Can it include comments, for example? Under option 2, we have stated very clearly what wording we should use to describe this scope. Should we say parody, satire, caricature, or pastiche? Or, as we said, should it be comments on an economic, social, or political issue? If we go for such definitions, or if we want to use such wording to describe such comments, then would we deviate from the word of parody as used in other countries, so that we cannot borrow the case laws of other countries? But that is a factor of consideration, and we have an open mind. If in the Hong Kong situation we want to describe the word like this, we would be quite willing to and happy to consider that. Next, Lo Wai Kwok. Between the freedom of speech and creativity and the protection of intellectual property rights, I think there should be a balance. And it is not just a matter for Hong Kong, it's an international concern, as stated in the paper. There are other jurisdictions who are updating their copyright laws. Hong Kong should look into those to see whether we need to move ahead with the times. I think the consultation will not be easy because the public, including netizens, may not understand the definitions too well. I myself, for one, don't understand these. Say, for example, on TV, we may have an imitation competition, for example. Would it be a problem? Miss Anne Chang is not here. If Anne Chang is going to imitate a certain female kung fu or martial arts actress, would that become a kind of parody? Mr. Charles Mock was talking about non-copyright infringements, and that leads me to another point. This may not be about copyright. Miss Anne Chang may assume another image, and this may not be about copyright. But then on the mainland, as you know, you also have so-called image rights. So I'd like to ask you whether this would also include image rights. What is your view at this stage? I think the consultation will be necessary, but in the process, you must provide more information, including the progress achieved in overseas jurisdictions. As I was saying, as Mr. Charles Mock, he was just sitting beside me. And I believe the public will also have difficulty with the examples I quoted. What do you mean by copyright or image right? Very often we harm people who are not protected by copyrights. Some parodies may damage the image of certain people, and it can become a kind of libel. Now, can you tackle those within this law, or should we go for libel laws? I think the members of the public may be concerned about these issues. So, Secretary, can you make some initial response here? Thank you very much, Mr. Low. I'd like to say that we are not talking about image rights, but other things. We are just focusing on parody within copyrights protection. As you have heard me these few days, we just like to focus on parody. Let us not talk about other things. We are talking about this important issue, both for netizens and copyright owners. And we like to show you our sincerity that indeed we have an open mind so that we can really delve into the issue. So we're just talking about parody. And we'd like you to comment on possible exemptions and the conditions for granting exemption. Mr. Low asks for more information, but actually in the consultation paper we have told you what other jurisdictions are doing. The information has been extracted for your consideration. And there is no common definition of parody. We have looked at different jurisdictions, but even in their laws, we cannot find any definition on parody. The court will make a judgment. Some netizens say if we leave everything to the court, things will not be clear. Well, this is what other countries are doing. Is it that in Hong Kong we have a special situation, so we want to define the word? We have an open mind on this. Amongst the factors for consideration, we can make reference to other countries. Maybe it is an economic consideration, or whether we want to consider the making use of the product to a certain extent so that there could be a replacement of the original product. Now, these are things we want to consider. We hope that there could be a rational discussion. Please do not use labels. Just now, I heard that netizens or other people may label this the Cyber Article 23 legislation. Let us be rational and open-minded. Thank you. You did not answer my question. Image rights. Is it that it is not subsumed under copyrights? Because that can bring about more problems. Because image right is something done on the mainland. From what I know, Hong Kong does not have so-called image rights. Director? No, we don't have that. Sin Chung Kai? Chairman, I welcome this consultation exercise. The consultation exercise is clear in saying that exemptions or exceptions are to be provided. In other words, this will be good for parody creators, let's say. Right now, you may make a parody and keep it to yourself, but now you can distribute it on Facebook, and there could be a big impact. Now it seems we have more time on our hands. Let us make use of the opportunity to do an in-depth review. If we don't do that, every time there is an amendment to the copyright ordinance, people would revive the issue to say, you have not exempted parody. As the Secretary was saying, we may have 3 to 4 months to do an in-depth review. I think that's good. But I like to make 2 comments. I like to ask the Secretary to do more. Perhaps you can make use of PowerPoint or other forms to explain the matter online. please try to use less legal language. I know this is a legal matter, but netizens and the public may only spend a minute or two reading a message. But as you know, that may only cover the preamble of a legal document. However, netizens may not read on. So I think you need to make use of new ways and means to explain things to the public. As our members were saying here, that there could be the image rights, etc., and other people may naturally think of things that do not have to do with copyrights. I think members here are reflecting the suspicions and doubts of the public, and these doubts and suspicions are quite reasonable. What we are talking about here is to ask you to make use of an official website to clarify things. People will copy and paste from your website, but I want you to be clear and concise in your message and let the public know the focus of your consultation exercise. It is a 30-odd page consultation paper. Can you not make it simple for netizens? Netizens depend on their feelings and emotional reaction, and they are already calling this a Article 23 legislation. And if you talk about exemptions, what kind of exemptions are you talking about? It is always good to provide exemptions, but netizens still have this feeling that it is a Article 23 legislation. I'm not saying this is the mistake of the administration. I believe many years ago, the Director of Intellectual Property told me, Mr. Peter Chang told me, that copyright law is the law of lawyers. I have lawyers sitting in front of me. I think what he meant was that the copyright law was a law difficult to understand. Now, of course, sitting in front of me is a barrister who is well versed in copyright laws, so I shouldn't say more. However, it is a piece of law that is not easily understood. And copyrights can affect many people. I don't need any answer, so I think you should go for simple language to issue a simple message. Thank you, Mr. Sin. You're correct. This is a complicated issue. It is difficult to explain matters in one or two words. But as I said, there are guiding principles. And that is that the law will be relaxed, that there will be more freedom of expression. And in this consultation exercise, we would like to strike a balance to protect the various rights. Issuing a clear message is important. We will organize forums, but we will also try to explain online so that netizens and the public and copyright owners can know the contents of the consultation paper clearly so they can comment on the options. Thank you, Secretary. You have heard, members. We all welcome the consultation, and I hope that you will try to see how you can extend the consultation period, because I expect a lot of controversy to come up. And as you have heard, try to see whether you can have a definition of parody works, and also the definition of secondary creation. I hope you will work more on those fronts. Thank you, Chairman. Sorry, Mr. Ma Feng Kwok. Sorry, I don't know why I have raised my hand for so long and yet you did not call me up to speak. Sorry. Since I represent the cultural, performing arts and publications industries, I like to speak on the issue. These sectors rely on copyright a lot to survive, so I welcome the amendment. Hopefully, you can pass it ASAP so we can dovetail with international practices. Another point, the balance to be struck between copyright owners and creativity. You want to draw a line somewhere. What I want to say is cultural and creative industries depend on protection of intellectual property to survive. In fact, they also depend on creativity. They would need a seamless merging of the two before they can survive. People say these two are contradictory, but actually no, they depend on both to survive. Some people say this will affect creativity. I have always disagreed with using the term secondary creation because it is not defined in a good enough way. If we use the term secondary creation, it will take us nowhere. Now we should narrow it down to this possibly controversial scope, but I believe it is a narrowing of the scope. I think it is a wise way of doing it. And in the end, what kind of definition we would end up with, I would respect the consultation process. I hope views will be expressed fully by all quarters. I agree that we can extend the consultation period because we are going into a recess.
Well, let me put it this way. Whether it's option 1, option 2, option 3, the most important thing is how we respect creativity. We should respect the original production. If we do not respect the original, and then whether you call it parody or secondary creation or caricature, they become meaningless. The original production is very important. And because original production is very important, we need to give it a certain period of copyright, say many years. And then by reproduction, they can get the original producer will get the economic benefit. Now, who will attach importance to this bill? They are the original producer and also the those who have the copyrights. How do we protect their rights? When there is a complaint, then action will be taken. When there is a complaint by the original producer, then the government will take action. Even if infringed product has been seized, the government has to get the copyright holder or the original producer to confirm whether there is an infringement before action is taken. That's a very important element in law enforcement. If the administration can explain the law enforcement procedures and law enforcement standard, that will be very helpful. In the cyber world, the procedures may be different, but if this can be explained, it will allay the worries and it will address the concerns of the trade. I agree that creativity is very important. This consultation is to balance copyright and the creativity and also the rights of users. The copyright owner plays a role in terms of prosecution. The copyright owner has to confirm that there is a copyright and he is the lawful owner of the copyright. And the infringing product infringes upon the copyright. And the C&E department has to gather enough evidence in order to hand over the case to the DOJ for considering prosecution. With regard to infringement cases, the government cannot exclude the copyright owner. Thank you. You've heard our views, Mr. Secretary, and time is up. I hope that you will consider handling the consultation period. We'll try to arrange a meeting in late October or early November. Can there be a joint panel meeting? I think the panel is more focused on discussing this topic. As for the ITBP, they may focus on other matters. Now, after we fix a meeting date, I will welcome the ITB panel members to join to attend our meeting. I think that will be a better way. Okay, item 5. This is the last meeting of this panel of this session. I would like to thank the Secretariat, the clerk, for helping us. And Annette, our clerk, has just been promoted as Chief Secretary, Chief Council Secretary. Congratulations. I wish you to have a good holiday so that you can fully recharge and you come back. Thank you.